If it is not on paper, it did not happen. So let's call it the paper trail architect because we are building a case, and typically from the ground up. There is a mind shift that has to happen. This mindset is going to shift from I need to document everything and say all of the details to why am I writing this down and what am I trying to prove? Hello, hello, hello. Today I want to talk to you all what about seems to be coming up over and over again. Documentation, how to build my case from it. What's the whole point of this documentation, Bridget? So let's call it the paper trail architect because we are building a case, right? And typically from the ground up. So let's get started. The most important thing that I feel I need to address is when we're documenting and the purpose of our documentation, there's a mind shift that has to happen, right? This mindset is going to shift from I need to document everything and say all of the details to why am I writing this down and what am I trying to prove, right? So that's the shift that we're going to be going through. The golden rule, always and forever until the day you die, and this is something that as a paralegal I did every single day in my career. If it is not on paper, it did not happen. If you did not document that conversation with the client, it didn't happen. If you didn't write it down, it did not happen, okay? Always, always, always document. It is a CYA. The reality check of the whole thing when it comes to documentation is it can be very confusing, especially when you're trying to incorporate everything that's been happening at the same time. A judge doesn't care about any particular parent's feelings. They don't care about what's fair, what's not fair. If they cannot see a pattern of behavior, they're not going to pay a lot of attention to it, right? And you might think that your pattern of behavior is clear as day. You might think that you've documented evidence that shows that dad is verbally abusive to the children. You might feel that that's true. Have a third party read your documentation to see if that's the case. Ask them, what is your understanding of what I shared with you in writing? I'm curious to know. As an architect with our documentation, you have a goal. And being the architect of your case is you're constantly building. You're building from the communication stage. You're building from writing down in your journal, writing down in your documentation kit, whatever you're using, you're building the case. And you're wanting to kind of close the loop when you're documenting. So if you're left with, after reading something that you've written down, you're left with more questions, you have to ask yourself, did this documentation answer any questions, or can it answer any questions that are coming up? Or is it leaving me in a place of absolute silence because I don't know what else to do? If we were to, I'm going to use an example. I read a lot of declarations and a lot of documentation. I go through them every single day. And I actually looked at a really good declaration not too long ago. And the thing I liked with the declaration, and if you're not familiar with them, think of them as like a sworn statement that is attached often to, a request for an order, you're filing a motion, something with your custody action. Okay, that's the point of a declaration. Think of it as a sworn affidavit. And you want it to be able to flow. You want your declaration in so many ways to tell a story, but we're not writing a story like a first grader using all of the adjectives that the teacher told us we needed to write, right? We're going to just stick to the bones, the main skeleton. What are the points? How many sentences do I need? What does the sentence need to convey? This declaration that I read, it had a flow to it. There was one particular interesting thing that I noticed about the declaration was that it was written in a way like the parent was a therapist, right? I'm trying to help the children regulate their emotions. They were really dysregulated. A lot of psychotherapy language was used in the declaration. And this is really hard for us to stop because we all communicate fairly well and we understand regulated nervous systems versus dysregulated nervous systems. We know the terms because we've been studying it. Part of our healing journey, we understand what a therapist has said about the things that we're enduring and we're experiencing with our kids. It doesn't mean that family court is going to understand the same language, one, and you don't want family court to later look at you as if you think that you're some kind of expert versus the parent. So I made the comment of, I want them to rewrite the things in their declaration in a way of it being a little bit more familiar. Think of, is this a message that maybe it's something I'm exchanging with a friend, right? Like thinking of that level of being familiar and cleaning up some of that language, right? The psychotherapy analysis stuff. We want to get rid of it. The reason I say to stay familiar in the writing is I'll tell you a story. I have so many from my life, it seems. But I remember sitting in the courtroom several years ago in family court, and opposing counsel they were just going into me. They would not let up. When you first take the stand, you know that you're asked, hey, can you please say your name? Can you please state your address? Can you please state your profession for the court, right? And you share those things. And when I shared my profession as a paralegal, there was a lot of attacks that came afterwards. What were those attacks? Well, is it fair to say that you are an expert? No. Is it fair to say that you are a member of this courtroom? Like, as if I was a court official? No, that's fair to say, but that's what they were going for, right? They were trying to attack me in a way of like, as if I had some kind of unfair advantage over dad. It didn't stick, but I had to deal with that for about 5 or 10 minutes of the ongoing BS. And I remember then going back and looking at my declaration, which was like part of my motion. And I realized what I had done when I was presenting it, and I had written it this way, was I was following a sequence of events, right? The things in my motion to modify and my contempt, they were all written in such a way of this flow. We could see a gradual buildup. We could see a gradual change in events. And I think that that's really significant because it shows how we're observing this behavior over an extended period of time. It doesn't show, like many people have this fear of, well, what if a judge asked me why I didn't take any action on this before? What if the judge asked me why I didn't do something before now? Well, a way around that is saying, Your Honor, I tried tirelessly to navigate the situation on my own. I tried everything that I possibly could think of to improve the situation, but it all failed. And so at this point, I am reaching out, asking for the judge, for the court to step in and to, take some action here to assist, right? That's how you get out of the, well, why didn't you do anything beforehand? Well, it wasn't that I wasn't doing anything, right? Because you were not doing anything. You were still trying to problem solve. Instead of thinking of ourselves as a victim of our circumstances, yes, we have been victims of abuse. Yes, we are victims of our ex and what they have done. You don't have to stay there. Staying in a victim mentality is dangerous. It will not allow you to grow. It will not allow you to fully heal, and you will stay stuck when you continue in that mindset. I want you to look at yourself as a resilient badass who's a problem solver. You're a problem solver. Every single problem that has come before you, abusive situation, name calling, withholding, whatever, you have solved the problem when you were faced with it, right? And maybe the resolution was you not engaging any further. That's still a resolution, but you're a problem solver. If I think of all of our documentation and I'm the architect of these cases, I dumb it down. I simplify it down to 3 things that we need in our documentation. And if you heard me say this before, I'm sure you're gonna be like, oh my God, she's repeating the same thing again, right? 3 columns. There's 3 little steps that I like to track, right? The date, the event, the behavior, the impact on the minor children. I talk about this literally all the time. I need to have like a little thing that it is something that is expressed in my documentation kit, but I simplify it for you now even more because sometimes there's a lot of overthinking. I need to show that this behavior falls under neglect. I need to show that this behavior is coercive control. No, you just need to share the behavior. I want to pull up for you something that I was reading a little bit earlier about documentation. And okay, here we go. So documentation overall, it is your notes behind the scene of the story that you are telling. What does that equate to? What is the story that you're wanting to tell? I don't encourage you to shit on the other parent all the time and just be like, dad's doing this wrong. My ex is doing this wrong. My ex didn't do that. Oh, now they got the new partner involved and now the new partner's doing this, that, and the other, right? We can say the things that are happening that are bad or how they're not following the order, but are you also going back and talking about your problem-solving ability? No. This is where a lot of people are missing out on this part of like, hey, yeah, all this stuff happened. But what did I do? Right? He was yelling at me in front of the kids at the exchange. What did I do? I grabbed the kids, put them in the car, and I removed them from the situation so that they were no longer involved in adult conflict. Could you have prevented what had happened from happening? No. But you took action steps to help the children. When you're using your documentation to later look at, okay, how can I file for a motion to modify? How can I file for contempt? If you have an order in place and you're wanting to change your order, the first thing I'm going to ask you to do is, are you tracking all of the other parents' violations of the custody order? If you are not, you need to start doing that. Now, don't get into telling me this, well, that's not in the kid's best interest. That's not in the child's best interest. What does that even mean anyways, guys? What's in the child's best interest to mean? It largely can boil down to one person's opinion. What if it's the judge's opinion that something's in their best interest, but it's not your opinion that that's in their best interest? Looking at filing for contempt is the easiest way at looking at a modification. So thinking of, all right, I've got all these little subparts of my order regarding transitions, exchanges, supporting the child, not bad-mouthing the other parent in front of the child, all of the things, right? You don't have to write out, he has violated page 3, paragraph 5. You don't have to do that. Just write out and track the violations of the particular order. And you don't even have to be fancy about it. Just write the shit down. If you do not have at least 6 months of violations that you've been documenting, you need to keep going and keep documenting further. I feel like the child is in danger. I feel like my child is not safe, Bridget. I don't know if I can wait that long. I hear you. If there are major safety concerns, and I'll get into what those could be in a minute, then you need to look at filing something ex parte, filing an emergency action, an emergency modification of custody, an emergency request for custody. What constitutes an emergency custody arrangement? I'm going to read it to you so that you know. Okay. In North Carolina in particular, because this is where I live and I'm familiar with the laws here, but they're almost very similar in every place. Emergency custody, also known as ex parte, that means one party. It allows for an immediate temporary change in custody without the other party present if the child faces substantial risk of bodily injury, sexual abuse, or removal from the state to avoid jurisdiction. Is the other parent threatened? Have they threatened to remove the child from the state, to take them out of the country even? The orders of any kind of ex parte are temporary. You typically are put before a judge and the other party will be present anywhere between 10 to 14 days after. Most areas, it's 10 days. If you're thinking of filing an emergency action, you better have a damn hell lot of proof. Is your child in imminent danger, or is there a serious risk of abduction, physical abuse, ongoing physical abuse or harm? I sat in a courtroom in Durham County, North Carolina, again, years ago, as I was waiting for my case to be called, and I overheard an instant of an ex parte that was filed. And this was a protective dad that was bringing this action. Dad had an attorney, and I think opposing counsel had gotten a wind of this emergency action that was being filed. And the case was the two children, preteens. I don't think either one of them were above the age of 13, but they had been left at home, and one of them had accidentally had something catch on fire. Not sure what it was that caught on fire. I don't recall those details, but something caught on fire. Maybe they were cooking, or there was a candle that was on. Something was catching on fire. The fire department had to come to help put out the fire. And the judge asked the protective parent who was bringing this action if he felt that the children were still in imminent danger. And his answer was yes. Right? I feel like this is really concerning. There was a fire, and it was interesting because the judge didn't change custody initially. The judge wasn't taking any change in custody and giving the children, removing the children. At that moment, the case continued, but didn't remove them from the other parent's home. So dad spoke some more with the attorney and was indicating, hey, I've got all of these things for the children at my home. I've got spare clothes. I can support them with school. I can do all of this. I know that they're maybe not expecting this, but one of the children said that they were really scared. That they were scared of not being supervised at home, not having mom at home. And I think it was that there that got the judge to change custody because the child was scared. Now, did he have substantial evidence that he brought to that courtroom? Yes, he did. There was even a report of the fire, right? Like, this was actually occurring. The children were in the front yard because of the fire and the other parent was not there. The thing that he hadn't done before was state how the child was impacted other than the obvious. All right. So most people do not fall under an emergency category. If you feel like you're ever in an emergency situation and you need to take action, filing for emergency custody, the worst thing that can happen is they say no. Then you have a full out hearing 10 days later, you present your arguments and see if there's a change in custody. It's not a wise way of going about modifying custody if it's not really an emergency basis. All right, so let's take a look at our documentation, right? You've got your documentation with you, you've got your date, you've got your event or behavior and how it's impacted the child. All right, Bridget, I hear what you said. I've got to have at least 6 months of contempt, of violations of the custody order before I think of making a move. Okay. Wow, I've got 7 months. Okay, I've got it all here. I'm checking all of your boxes. Now what do I do? How do I start with the process? Well, I am not a lawyer. This is not legal advice. This is based off of my own personal lived experience and my professional understanding and experience in the field. You're going to file for contempt and modification, and you're going to file it at the same time. It's worked in my case. It's worked in I don't know how many other countless cases that I've worked on and helped. Filing the contempt shows and lays the groundwork for a substantial change in circumstance, showing how custody needs to change. There's been, what is one of the substantial changes in circumstance for the modification? Well, the other parent is unable to follow our custody order. They have zero regard for any kind of rules, regulations, orders that are in place. All right. So I'm going to fill out the contempt. I'm going to work on that. I also like to look at child custody statutes. I am looking this up while I speak to you all, and it's being done in real time. I'm going to read to you the statute in North Carolina. I did a Google search. It's that easy. I'm going to read to you what the statute says and how I'm going to incorporate this law, the statute, into what I write. All right. In North Carolina, child custody is primarily governed by General Statute 5013.1 through 5013.9, okay, which mandate that court determine custody based on the best interest of the child. Now, I don't like you ever using that language, and I'm going to give you further explanation. Hang tight. There's no legal presumption for mothers or fathers and joint custody is considered. So there's no legal presumption that it's going to be for moms that this is going to happen or for dads or whatever, right? The key factors in custody are always safety, domestic violence, parenting ability, and the child's developmental needs. The key aspects of North Carolina child custody law, I'm going to read you the statutes. Talks about the best interest standard. This is what your attorneys are referring to. This is what your high conflict acts refers to of that's not in the child's best interest. I don't think that's in the child's best interest. This is what they're trying to get at, but they could actually just say the words and it would be more effective because there's vagueness. The best interest standard is the court's focus is on the child's welfare, not on parental rights. So this is this understanding. What is a child's welfare, right? Like, let's say your high conflict ex, I read a message like this maybe 2 days ago that I was responding to with a client, but it was, hi, I'm wanting to let you know that unfortunately I'm not able to take the child to their hockey practice this weekend. I'm unavailable. Is that in the child's best interest? Is that the child's welfare being looked out for in that situation because the other parent has a personal conflict and cannot take them? No, one could argue that that is not looking out for the child's welfare, for the child's best interest. It would be different if the ex were to have said, hey, Bridget, I know that Jonathan has hockey practice this weekend. I really wish I could be there to take him. I've had a conflict come up on my calendar. I'm not able to make it. Do you think we could either swap weekends or would you like to come and pick them up and take them to the practice? Thanks so much. Your ex is not going to do something like that. You know this, right? What did I do with that message? What did I show you? How the person writing it is putting the child's needs before their own. That's the child's best interest. So instead of saying that's not in the child's best interest in messages, I want you to show with your words the child's best interest. And don't say those damn words. Your ex is not going to do this, but it doesn't mean that you don't have to communicate that way. In fact, you should be communicating this way. You should be communicating as if you are co-parenting and you are looking out for the child's best interest all of the time. You don't expect the other parent to actually cooperate. You're not expecting the other parent to actually do what you're asking. Maybe they do once in a blue moon, but it's going to be a rare circumstance. What you're doing is you're being an architect. You are building your case. You know that they're going to say no. You know that they're going to refuse. That is the point. Let me go back to what the child custody law says. Okay, legal and physical custody. Judges determine legal custody, decision-making, blah, 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 right? When we're talking about overall the well-being of the child, it falls under that category, right? The best interest is the welfare. This is the general statute of North Carolina. And the general statute tells us all these different terms. It gives us all these definitions. Look up the general statute of child custody in your state. I'd say about 75% of you never do this. Do it. The language that is here is important for you and how you apply it. So again, it's giving us different definitions, international applications, etc., communication between the courts, blah, 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 blah. This is a lot of legalese, okay? But it continues to go on. Every single state has what the state is looking for written into their law. Talks about temporary emergency jurisdiction. Why can a judge issue any kind of ex parte motion? But you guys get the point, okay? So when I have this statute pulled up, I can look for particular information that I would like to pull out showing how it's a violation of the statute. I'm not going to say you're violating statute, blah, 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 blah. I will list what is written in the statute. When it comes to contempt, you have to be able to show that there was a willful refusal to follow the order. Where did I get the word willful refusal? From the statute, from the law. And I use that later in my motion for contempt. Now, there's a difference between using that kind of language versus kind of like a psychotherapy analysis that I was talking about earlier on. We're using the statute, brief snippets of it, to help the reader identify what has actually occurred. And what part of the law is this following or not following? It's actually wise that you read through your statute. I'm scrolling down and it doesn't take, this would take me probably 15 minutes to read the whole thing, to take some notes and better understand. Filing the contempt and the modification and presenting just the evidence overall in your cases, you should be utilizing that same type of formula. All right, I'm using the formula, I'm listing the things out. I've talked about the different violations of our custody order and how it was a willful refusal. Dad willfully refused to return the children to me 100 times in the past 7 months. Wow, okay, that's a significant amount of times. You guys have heard me talk about it before. Why do I use the number? Because the number is significant and it stands out. Right? If dad had custodial time or the other parent had custodial time, parenting time, and they had in the past 6 months, 50 overnights, let's say, and they didn't utilize all of them, they were unavailable or whatever, they only utilized 30 of those overnights, I would state that, right? Of the 50 parenting days that the other parent had, they only exercised 30. How did that impact the child? Well, we had to change our schedule. We had to rearrange our plans. We're feeling rejected. They were feeling sad. They were feeling abandoned, whatever. Don't overcomplicate it. I'm going to pull up something that you all have written within the community because I find that it's helpful, or maybe I shared it. Cleaning up documentation, sticking to what is important. This has been an ongoing discussion in the collective. How do I clean up my evidence? What is important? Since, we're taking action to file something in 2026, my attorney and I. Should I incorporate stuff from like 2023? Well, my answer to you is always going to be this. When was the last date of your order? When was the last date that this order was signed and filed and implemented? You want to look at everything that's relevant that has happened since the date of the last order. Not before, but after. Why? Because we now have a new court order in place that is the law of the land, and it's not being followed. So what happened before that to the court and in the court's mind doesn't matter. It's insignificant. If you wanted to bring judicial notice to something, let's say your ex you're trying to get a modification because they have a drinking problem. Well, you could bring judicial notice to the DWIs that they've had. Let's say they've had 3 in the past 2 years. That's significant, right? Your Honor, I would like to bring judicial notice to these cases, and you better have the damn file numbers available and mention them. They are significant as, this individual has been arrested on 3 different occasions for driving under the influence. That is an ongoing safety concern. I have mentioned it with the other parent, and I'm hoping that the court can help implement safeguards for the children moving forward so they can continue to have visitation. It sounds very different versus I don't want him to have the children ever because he's got a drinking problem. It's like I identify he's got a problem. Why am I not doing the other? Because the family court system is kind of like you in the relationship back in the day. You know how you believed your ex's lies and you gave him the benefit of the doubt? Right. They give the benefit of the doubt far too many times. Okay. So if you come across as, your ex is going to be charming and charismatic and all of the things and playing victim and oh, what was me, right? But if you come across as not being aggressive, but rather firm and assertive of hey, these problems have occurred. I have tried to problem solve them. We haven't gotten anywhere. So I'm hoping that there's additional remedies. Do you feel the difference when I present it that way versus Your Honor, he should never see these children again? There's a huge difference. You feel it. You feel it in here, right? You feel it in the pit of your stomach. Your words come out differently. Your tonality changes. Check your tone. Practice speaking in front of the mirror. Listen to yourself. Read out the things that you're wanting to put into your contempt motion, modification filing. Read it out loud. How does it sound? How does it make you feel? Now, valid if you feel anxious, totally valid. You might feel anxious remembering some of these things that have occurred. Why? Because you're triggered. But overall, apart from that, how are you feeling? Your gut is a really good indicator. So cleaning up the documentation, you don't have to worry about getting it into all of these categories. You can categorize the documentation later on. Let's say you have 20 instances that you've documented over the past year, and it looks at the children being neglected. What falls under that? They hadn't been fed. They hadn't been provided a place or a space for them to have good hygiene. They weren't brushing their teeth. They had cavities, right? They didn't have clean clothes. They didn't have clothing that fit them. Y'all know what I'm talking about. They're coming back home in clothes that were from fucking 2 years ago. Your ex does it to punish you, but it's punishing the child. And they don't see it that way. They know that you love the child more than anything in this world, and they're wanting to hurt you. It's petty bullshit. Okay, so categorizing it that way, you can, but it's not necessary. Is the non-categorization of your documentation going to make or break your case? No, it's not. It's all in the presentation. There was another comment about parents suddenly being unemployed right before court. You've already gotten your action filed. You're moving forward, with your documentation in this modification action. You're like, I've got it already. I've got it ready to go. I can prove this is not in the child's best interest. And then the other parent quit their job and they're suddenly unemployed so that they can be readily available for the child. Okay, I want you to think about this for a minute. Because when that happens, you've got to ask yourself, how is this person surviving? One person unemployed. The cost of living is astronomical. How could they reasonably argue that they can provide for a child during that time? Now, they can care for the child. Okay, great. But how are you going to work? How do you pay your bills? How do you buy food? The unemployment situation is a temporary situation. It will not stay that way for forever. So when you run into situations like this, because it is common, I see high conflict people all the time suddenly becoming unemployed and they're now ready to be the parent that they never ever were. Work with your attorneys and formulating questions surrounding their unemployment. How long have you been unemployed? Okay, are you actively looking for work? Are you receiving unemployment benefits at this time? Okay, so how much are your monthly expenses on average? How do you get the money to pay those? Okay, are you receiving food assistance at this time? No? Oh, okay. So how do you have money to pay for food? Would you be able to provide food for the child while they're in your care? What about diapers, right? Think of those things. It's not that we're attacking them or tearing them down, but rather we are presenting the information and asking the questions out loud that everybody's thinking and maybe they're not. And we just need to bring it to their attention. When you go through your documentation, and let's say you're going through years and you haven't had an order in place for the past, I don't know, no changes to your order in like 5 years, right? Well, do I list everything for the past 5 years that has happened? No. What are some common behaviors that have continuously occurred? Look at the most recent ones first and move backwards. In that case, you want to have almost a reverse order chronology, a reverse order timeline. So the most significant, most recent, impactful thing is going to be your starting point, and you move backwards from there. And it can be listed out in your motions. The way I thought about this was, how could I document things in my motion or share my motion for contempt modification with the judge in a way that was going to be quick and easy for them to understand? Okay, maybe there was several pages to it, yes, but it was a quick line, right? A quick sentence across the white piece of paper. Dad failed to exercise his parenting time. Dad willfully failed to exercise his parenting time on date, so on and so forth, right? I'm keeping a very short, sweet sentence. I did not describe how this has impacted my mental health. I did not describe how it was negatively impacting even my children's mental health. I just stated the facts as to what was going on. And then I had attached to that, I was blessed. My children had great therapists, and the therapist had provided a letter stating the things that my children had shared and, the therapist's overall recommendation. I had touched on the children indicating that they were scared, that they had a lot of anxiety surrounding going back. They didn't want to go back, and why, right? So that's something that I had done, but it wasn't like the highlight of what I was sharing. If you're going to present information about your child's mental health, mental well-being, I do strongly recommend that you have the backing and support of the therapist, that the therapist is maybe making that observation and recommendation, not just you. How many times have you all heard me say third-party neutral professional at this point? Quite a lot, because it is significant, it is important. Even if maybe the therapist writes a letter and you feel that it's not as supportive, it does show that the child is receiving ongoing therapy and there's a reason for that. Think a little bit outside of the box. I feel like all I do is like beat a dead horse talking about documentation. Let me take a moment away from that, and I want to chat with you guys about something that I read of navigating living with your abuser while you're still going through the divorce process, right? I will say that I had to continue to live with my ex before we were even separated, right? I was staying in my children's bedroom. I slept in a bunk bed with my kids, with my youngest sleeping in my arm every single night. And my oldest son was on the top bunk, and my daughters had their bedroom. I survived. I would buy rotisserie chicken from the grocery store, some bread, those bagged salads. That would be dinner quite frequently. And I would eat in my children's bedroom with them on the floor. For them, it was fun because I made it fun. I told them we were having a picnic. We can break the rules. It's okay. We're going to have a picnic. It's going to be fun. But I kept us all there together and safe because I knew that he would attack me at mealtime. He often did. Or he tried to create more issues in front of the kids. And I didn't want that to happen. Did I find creative ways to navigate that situation with my kids? I tried. I didn't stay in that situation for more than 6 months. And then I moved out. I had to save money and I had to find a way out. And I did. And I took my kids. But it helped me plan to leave. And I felt really stuck, right? This was my home. This was the mortgage that we had. It was in both of our names. I had all of the debt from the marriage because my ex thought it was a brilliant idea to get all these credit cards and then to just use them. And He refused to give me money, right? Refused to give me money to buy groceries, to pay the bills. So I was paying everything. If anyone were to ask him, he would say no, that he was the one paying everything and that I ruined him, right? We all know how the story goes. But I continued to have all of the marital debt. So for me to leave, this is not financial planning advice at all. I defaulted on all of my credit cards. I stopped paying. I'm like, what's the worst that's going to happen? They're going to blow up my phone and I'm going to ruin my credit. Okay, I'm going to ruin my credit, but guess what? I'm going to have so much fucking peace in my life. So I did. And I was able to secure a house to rent with my kids. And I had gathered the first month's rent and the deposit, which was a month's rent. I put the utilities in my name. We didn't have much. In fact, when I first moved into the home, we lived in that house for a whole week before I was able to get any furniture out of my house. He wouldn't let me, largely. But we slept on an air mattress. We ate on the floor. I laid a blanket down and I had very little things like the kids' clothes and toys, and we had a nice place for a bath. My ex hadn't had the address yet of where I was moving to, so I did have some peace there. I learned before from leaving him and moving into an apartment for a short period of time, he had the address and he started like pounding on the door of my first floor apartment in the middle of the night and on the windows. It was horrific, very triggering. And so I knew like leaving again, I couldn't give him the same information, right? Is it possible to still leave the situation when you're going through a divorce? It is. And for any individual that tells me that they feel they can't leave, I will tell you, let me show you how. There's many ways that we can be creative. Am I saying that you're going to be really comfortable at first? No. Am I saying it's going to be easy? No. I am the same mom that once I didn't have enough money to pay the water bill and it was shut off for a day. And then I got paid, right? It was like I didn't have the money, but then I was going to get paid the next day, so I could pay it then. And I knew the water was going to be shut off. I went to the grocery store. I bought with a few dollars gallons of water. I was able to bathe the kids, like a little bit more than a sponge bath, but we all bathed that evening. We all had water to drink. We had a roof over our heads and we were fine. You all, no matter where you are, you may not see the light at the end of the tunnel right now. And I remember saying this so much, even at the workplace with clients that I was talking to on the phone who were in really desperate situations. They were like severely injured, unable to work, right? Receiving workers' compensation. And I remember telling everybody, there's a light at the end of the tunnel. And in my job, I would tell my clients, there's a light at the end of the tunnel and I'm going to get you there. I'm going to hold your hand and we're going to get to that end of this tunnel together. And I realized that I started believing that to be true myself. My kids were still being abused, having to see dad. I was still dealing with a lot of back and forth, the constant, I'm not available. I had to drop everything in my life to take care of our children, but I managed, right? I kept going to find the light and I wanted to stay in the light. Maybe your light looks different than others. Maybe you being in this situation right now, you don't feel that there is any kind of resolution. You're stuck at 50-50, no modification in sight. You will not stay there for forever. But something that I think is really powerful for us to know and to hold on to is it is so much better to have your children 50% of the time than not at all. And holding on to 50% and not getting less than 50 is important. And you're dealing with someone that's high conflict. There are so many horrific stories all over the internet about family court and how brutal it is. And this is true. There are really horrific stories. But I don't want you to believe every single story that you hear as it's going to be yours. Because it's not going to be your story. Your story, you're still writing it. Your story has many chapters that haven't even been thought of yet. So I want you to keep going. Even though there's fear, even though you feel like, I don't know what I'm doing. Am I doing this right? Put aside everything that I tell you. Put aside everything that I'm teaching you right now and ask yourself, what does my gut feel? Is my own intuition telling me that this is right? Is my own intuition telling me that I could maybe change something? Do I have some anxiety around this? Am I feeling right now like I have a lot of self-doubt? Am I not doing enough? Am I enough? Am I doing enough? I need that. I hate that feeling. You are here with me. You are listening to me. You are learning and growing, educating yourself as much as you possibly can. You are doing more than enough. So I want you to keep going and hold on to your intuition. Listen to others around you regarding your case. What does your attorney say? What's the feedback that they're really giving you? And when I say listen to what they're really saying, I want you to turn off the negative self-talk that comes up when you hear other people's words. See, I knew that was bad. I knew that this was going to happen because I know that we all have the negative self-talk that still comes through at times. It's important that you cancel it out. I will be back on live next week